All right. Hello, everyone, and thank you for joining today's presentation in the Practical IP for Natural Sciences webinar series brought to you by the SLW Institute. Before we begin, a few housekeeping items for today's discussion. If you have any questions during today's presentation, we encourage you to use either the Q&A or chat feature. This webinar will be recorded, and I'll send an email this afternoon with a link to the webinar recording along with the slides. For today's presentation, we have Peter Leal here to present on university licensing issues and give examples on streamlining the process and bring you through a sample licensing agreement pertinent to universities. With that being said, Peter, I'll let you introduce yourself and take it from here.
Hello, I'm Peter Leal, and I'm a registered patent attorney with the Schwegman Law Firm. I have a bachelor's degree and a master's degree in electrical engineering. I was in-house at IBM for 32 years, where I did primarily license agreement work, both hardware and software, as well as any other type of technological agreement that was needed, like development agreements, manufacturing agreements, and those types of agreements. I also do patent preparation and prosecution, as well as infringement studies. I would like to start by saying that originally this presentation was going to be given jointly with Jim Gould. Jim Gould was an attorney with the Schwegman Law Firm at the time this presentation was being put together, but he is now an attorney with a Schwegman subsidiary, so he won't be here today, and I'll be giving this presentation myself. But I wanted to give Jim a shout out for doing all the biotech research for the presentation. He did a really good job, and it's been pretty easy to follow his work and put this on by myself. So the agenda for today is we're going to talk about some university licensing issues. We're going to talk about a big year in university licensing, a watershed year in 1980 when 3 items happened, and we'll talk about those in detail. And then we're going to talk about streamlining university licensing, what universities are doing in order to make their licensing go more smoothly and bring in more revenue. And we'll talk about the University of Minnesota and also Pennsylvania State University. And then we'll talk about license agreement sections that are particularly relevant to university licensing. And then we'll finish up with some examples of relative provisions of a university license. This is an actual university's license that I've taken, and I've blocked out all the names so that you won't be able to see who's involved, but it's a real live university license agreement. So starting with biotech, as I think you all know, it's a very costly and risky business. You never know whether you're going to end up with a marketable product. A lot of inventions are made in the field that never amount to marketable products. There's a lot of cost in clinical trials, FDA regulations and the like. And so valuation is difficult. And universities also have some other issues because their interests and responsibilities as universities and their cultural differences, particularly with professors, I would say, can compete with usual business strategies for intellectual property. And you can see there, you can read those yourself, duty to taxpayers, particularly in item 2, interest in retaining use of their IP for research and education. We'll talk about that. There's actually an important case that came down about that has changed the structure of some university license agreements, and we'll give examples of that. Another point is that faculty inventors often have the primary goal of publishing their work, and this might be adverse to maintaining the work, certainly as trade secrets, and even as to patentable subject matter. I remember when I was at IBM, I had responsibility for the research division, which really is a a lot of people who are very much like professors, and they really more valued publishing their work than patenting it. And I think universities have the same issue. And then, of course, the last item here is governmental rights in IP generated from publicly funded research. That has to do with the Bayh-Dole Act, Birch by Robert Dole. That was 1980, and we'll get into that in detail. So, as I mentioned, 1980 was a watershed year for university licensing. Three things happened. First is the case of Diamond versus Chakrabarti came down, which allowed the patenting of living organisms. The second thing was that the process for biologically functional molecular chimeras was issued. That's really recombinant DNA. And then the final one was the passing of the Bayh-Dole Act. So let's start with Diamond versus Chakrabarti. Apparently, well, the case is that Chakrabarti had come up with a way to make a genetically engineered bacterium. And the Chief Justice at the time was Warren Burger, who hails from St. Paul, and he wrote the decision. The holding was that a live human-made microorganism is patentable subject matter. In other words, it is a subject matter for which a patent can be granted. And the microorganism constitutes either an article of manufacture or a composition of matter within the patent statute. You can see the key discovery there underscored. He developed a process by which multiple plasmids capable of degrading hydrocarbons could be incorporated within a hardy single bacterium, and this genetically engineered bacterium was capable of breaking down oil spills. And there's a nice summary of this in the paper down there at the footnote. Now, the second thing that happened was recombinant DNA, the patent for recombinant DNA. Professor Cohen, who was at Stanford, and Professor Boyer, who was at UCSF, worked together, and they came up with this invention of recombinant DNA. There was this collaboration between the two inventors, and Stanford took the lead, and the patents are now in the name of Stanford, so that there wouldn't be joint ownership, which could lead to licensing problems. But there is an agreement between Stanford and USF as to apportionment of royalties. A very interesting quotation here at the bottom of this slide. No one was interested in patenting in 1974, which is at the time, about the time that the patent application was filed, until Niels Reimer, who at the time was the director of the Stanford Office of Technology and Licensing, took charge. He had to be very persuasive with Professor Cohen, and reportedly convinced him to agree to patenting only after speaking to him like a Dutch uncle. Sounds like he made him an offer he couldn't refuse. Anyway, that's a nice quotation from this book here by S.S. Hughes. Actually, it's not a book, it's a paper. And interesting thing about Hughes, I don't know why there are no periods between S and S, but I looked that up, and he signs his name S.S. Hughes, just as you see it there in the footnote. So continuing on with Cohen-Boyer, the actual patent itself, the original and primary patent, issued in 1980, and there were two other patents that issued shortly thereafter. And the three patents were recognized as huge innovations and created an industry around genetic engineering. This licensing program around these patents has been called the gold standard of university licensing programs. Stanford, putting the license program together, had 4 goals. You can see what they were. They were primarily not targeted toward revenue enhancement, yet the patents generated over $100 million in royalty. And there's a nice There's a nice history of that in the book down here in the footnote by by Feldman, Koliani, and Liu. Now, the third thing that happened in 1980 was the passage of the Bayh-Dole Act. Before that time, inventions, the IP and inventions that were made under government-sponsored research was the property of the federal government. So there was not a lot of impetus for universities to move forward with patenting that, because they really didn't own the patents. But in 1980, the passing of the Bayh-Dole Act allowed universities to retain patent and licensing rights to inventions developed by using federal research funding. I'll show you there. You see the statute there under Section 202 of 35 USC. Each funding agreement shall do the following. The contractor, in point 1 there, must disclose the invention to the federal agency. And then here's the important part. In point 2, the contractor can make written election within 2 years after the disclosure to determine whether or not the contractor, here the university, will retain title to the subject invention. So you have to just notify the agency in writing. And there are some other restrictions. You've got to file a patent application, and the government will get a free license, and there are other things that go with that. But the passage of the Bayh-Dole Act was very important in allowing universities to own the inventions made with federal support. Now, here's a big question that came down. Who actually owns the elected inventor, the invention, the elected invention? Is it the contractor, or is it the inventor who makes the invention? And the case of Stanford versus Roche Molecular Systems held that the ownership really is in the inventor, which means that the university has to get an assignment of the invention from the inventor to the university. What happened in this case was that there was a Stanford University professor who did make an assignment of his work to Stanford, but then one of his managers at Stanford assigned him to work to a small company that was later purchased by Roche Molecular. And this small company gave the professor an agreement to sign. It was an assignment, and he signed it thinking he was doing the right thing. So what happened, if you look at the very bottom there, this is the way that assignment should be worded. The inventor agrees to assign and hereby does assign the intellectual property to the assignee. The Stanford license agreement at the time, and this was back quite a ways, said only that the inventor agrees to assign the invention. The Roche agreement said both the inventor agrees to assign and hereby does assign. The court held that since there was a present assignment at Roche, but there was no present assignment at Stanford, the invention belongs to Roche, and Roche thereby claimed claimed ownership under the Bayh-Dole Act. And the Supreme Court reasoned that since 1790, the ownership of inventions has always been in the inventor, and that nothing in the Bayh-Dole Act really changed that. So the bottom line here is, for universities to be successful, they first have to acquire assignment from inventors for each application, and that is certainly done today almost as a matter of course. Let's take a look at how difficult it is to make large royalties. This chart gives you some information. This has to do with Stanford's innovation history. Stanford has at the time of this chart, since 1970, they had 10,000 invention disclosures, 5,000 issued patents, 2,500 license agreements made with various companies, 77 license agreements generating $1 million each or so, and only 3 generated $100 million. So you can see how that focuses right down to a very few inventions out of the 10,000 or so that was made. Another chart here of interest is a graph of university royalties. 15 schools, as you can see them there, produce 70% of all patent royalties income for U.S. universities in 2014. One of the big ones was Northwestern, and that's their Lyrica pharmaceutical. And of course, Stanford continues to do well as University of California and these others. All the others have this smaller section here. So the story on university royalties is that most schools' tech transfer offices actually lose money. So if you look at this chart, they lose money covering salaries and operating expenses. 52% lose money covering those expenses. 21% lose money or break even after distribution of inventor shares. 16% overall break even, and only 11% make a net profit. So it's a difficult business. And so you really have to structure your licensing program well. There have been some new approaches at streamlining licensing in order to allow increased royalties. We'll talk first about the University of Minnesota, and then we'll talk about Penn State. The University of Minnesota has had some success with the Sleeping Beauty gene, the gene editing licensing patent. They made $18 million in 2015, $45 million in 2016. This is the patent number. It issued, as I recall it, back around 2002. You can see there, Sleeping Beauty is a DNA transposon used for gene editing purposes. There is a copy of the basic invention, which was to Maxwell Delbrück and Centrum, which is a German company. University of Minnesota did some investigating into its licensing program in the year 2014. They had a meeting with the faculty and industry members in hopes of increasing industry-sponsored research. They noted that industry complained of lack of certainty about whether they'd be able to get exclusive licenses to IP, and there were complaints about complex licensing negotiations for unproven IP and a real lack of certainty. So University of Minnesota did a really good job revamping their IP licensing program into two categories. Minnesota Innovation Partnerships includes industry-sponsored research, and they have a program called Try and Buy, where IP that has already been generated from sponsored research can be tried out, and if they like it, they can buy it under various options that you see here. I recommend that you take a look at this video on YouTube. This is a video put out by the University of Minnesota, and it's a really nice short video. It's about 4 minutes long, and it's really worth your time because it really tells a lot about the work that University of Minnesota did in revamping its licensing program, and they've really done well. Under their Minnesota Create program, sponsor has 3 different options: paying up front, paying a lesser amount, and then research sponsor can wait and see. And usually option A includes a bonanza clause that allows the University of Minnesota to participate if a given product is very successful and turns out to be a real winner. The Try and Buy program also allows the licensee to have low starting costs, only pay for IP that actually issues a patent, and they step up the royalty starting very low. Other universities have followed suit, and you can see them there: Georgia Tech, Iowa State, North Carolina, and so on. But the bottom line out of this chart is that universities are really looking into how they license their IP, and they're doing their best to streamline the licensing, primarily into giving licensees more choices of how they can license university IP, and it has resulted in more successful licensing. Pennsylvania State did a similar investigation in 2011. Ronald Huss, who was the director of the Technology Transfer Office at Penn State, did an investigation and looked at the years 2000 and 2006, and the annual revenue generated from licensing was less than $100,000. That's a loss right there. You know that has to be, that won't cover salaries. So he interested the university administration in revamping their sponsored research program, and a major change was to allow assignment of sponsored research in some cases to the sponsor, but yet Penn State retained a bonanza royalty clause so that if the product was a real success, Pennsylvania State would reap some of the benefits. Now, I'd like to talk about the license agreement itself, and this will be done in two segments. One will be the license agreement, talking about license agreement sections that are particularly relevant to university licenses, to university licensees. This does not say that these sections are not in business license agreements. It just says that they're particularly relevant to university licenses. First of all, within the grant of license, one of the things is to make sure that the university reserves the right to do research and use the invention also for academic purposes. And you've got to take care here because a recent case, Mady versus Duke University, which we'll discuss on the next slide, really shows that this reservation for research and academic purposes is very, very strictly limited, and you have to really expand it within the license agreement. And another point is, if it's relevant, there's certain reservation of rights to the sponsoring government agency. So, continuing with the license agreement, I recommend to your reading the paper here at the URL that you see at the top of this chart, 9 points to consider. It's quite a nice paper. But now what I want to talk about in this chart is the case of Mady versus Duke University. In Mady, Duke University had a so-called experimental use exception to patent infringement. In other words, it said this was an exclusive license to Mady, but Duke University received the right of experimental use. And the questions was, what is experimental use? And as you can see there in the bold type, the decision limits the permitted uses of unlicensed technology to what the case called aimless tinkering with patented technology, and sets the stage for infringement suits even against non-commercial researchers such as universities. And a nice quote from the case is that so long as the act is in furtherance of an alleged infringer's legitimate business, the act does not qualify for the very narrow and strictly limited experimental use defense. What does that mean? That means if you're the licensor, if you give out an exclusive license or even a non-exclusive license, and you retain rights for yourself, you have to really spell out those rights, because if the rights that you just retain for yourself are what you normally do in your legitimate business interest, then if you haven't spelled that out in the agreement, you are an infringer. In this case, Duke's legitimate business is teaching. So if they just said they had the right to reserve the IP for teaching, that was not enough under the case law. They really had to put it into their agreement. So to address the Mady issue, in recent license agreements, universities have attempted to make it clear that they are reserving rights that are broader than those allowed to a mere unlicensed party under the law. And and in order to do this, universities put reserved rights right into the contract so that they are contractually reserved rights. And we'll give some examples of this below when we talk about the university agreement in the last part of this presentation. Another section is consideration. Under the consideration section, a big point of this is milestone diligence payments. Yes, these do occur in business agreements as well, but not nearly to the depth that you see them in university licenses. And I'll give you another example later on. And we talked about bonanza royalties. Another provision that is seen in university licenses is that the sponsor of the research will reimburse the university for all costs associated with getting the patent, filing, prosecuting, and maintaining the licensed patents. And I have worked on 2 or 3 of these, and universities are really tight on this, and it's very, very hard, if even possible, to give them to give very much on this. Another part is diligence terms. Again, they have to meet certain diligence milestones to ensure that the technology is being developed and commercialized. After all, generally, this will be an exclusive license. So you want to make sure that the technology is being worked and that the licensee doesn't just sit on it and do nothing. As to indemnification, usually the university will require the licensee to indemnify the university for almost any kind of liability. And you'll see this in the agreement we're going to talk about. And also, here's a very important point. Universities do not like to give rights to improvements of the IP they're licensing. On the other hand, somebody who's taking a license certainly wants the license to cover improvements. Otherwise, if there are improvements and the license doesn't cover improvements, the licensee has to go back to the well, essentially, and seek another license, and nobody likes to do that. So this is a point that is negotiated in licenses, and you'll see in this license agreement, we're going to talk about how sometimes it ends up. So this is a real live license agreement. It's a university license from a university that you know well. It's copyrighted material, so we cannot give out this section of the presentation in our slides. It's okay for me to use it as a teaching purpose. That's a fair use, but we can't give out this copyrighted material. And as I say, this is an actual agreement from a university. So normally in the background, in addition to talking about the identity of the license, the university will generally state the government agency that sponsored the research, here the Bayh-Dole Act provision. Here in section 2.1b, under the license patents definition, we talk about improvements that we talked about a moment ago. And I'll show you that this is a very limited improvement section. If you look at B, it says any patents issuing on any patent application filed, and any continuation in part will be included as part of the license patents only if it's filed within 2 years of the effective date of the license. Well, continuations in part are generally what are included, are generally what the vehicle for covering improvements, because you'd like to get the original filing date to the extent that it's available. But here, this agreement from a West Coast well-known university that you know of includes in the license patent definitions only CIP that are filed within 2 years of the effective date. That's a very short time period. 2 years of the effective date of the license agreement is a short period, and in fact, the licensor here, the university, can even hold off if it wants to and file the CIP just a little past 2 years, and they'll be out of the letters of the license patent definition. So you see, this is very limited improvements. A second point is what is meant by exclusive license. This is an exclusive license, but it's not really an exclusive license. Here's what exclusive means. it means that the university will not grant further licenses, and that they'll disclose any prior licenses that have been granted. So all that says is there may be licenses granted in the past, and we'll tell you what they are, but you, Mr. Licensee, will have an exclusive only to the extent that we will not grant further licenses. So this is really a tight definition, and again, preserves the possibility of non-exclusive licenses to the university. And this is part of the streamlining that we talked about early on in this presentation. The grant itself, if you notice the way they worked out the exclusive license, the license is exclusive, and the exclusive right ends 8 years from the date of issuance of the first licensed patent to issue. Thereafter, the license becomes non-exclusive. So again, it's a very tight exclusive license grant here. And here's the part about reserved rights in the university. This goes to the Mady versus Duke decision that we talked about a few slides back. The university shall have the right to practice the inventions and use the technology for its bona fide research, including sponsored research and collaboration. So it broadens out the very narrow exception to Mady versus Duke University. And I would say that today, well, let me say this. This university agreement goes back to about the time of the Mady decision, about the 2001-2002 timeframe. If you fast forward today to 2018, universities have broadened out this exception in their own favor quite a bit more than you see here. Government rights, you'll see that the Bayh-Dole Act provision we talked about. Diligence, as noted earlier, the licensee has to agree to use commercial efforts, and we'll talk more about this when we get down to the attachment to this license agreement, which really spells it out. Also, the licensee has to give progress reports. That does happen in business license agreements as well. But if you notice how detailed these are much deeper than the usual business license progress report. Royalties, there's the usual minimum royalty, and there are earned royalties with different step down or step up, depending on how you look at it, versus net, based on net sales. Again, here's the patent cost clause that we talked about earlier on. The university will apply for patents, and the licensee has the right to advise university, and the licensee will reimburse the university for all patent costs. So that's, again, university favorable. Infringement by others, licensee will promptly inform the university of any suspected infringement, and then during the exclusive period, but only during, in this case, the 8-year exclusive period we talked about earlier, only during that period will the licensee itself have the right to bring suit. Interesting sublicense clause. Licensees shall pay the university 25% of all revenue received from sublicensing, and then it says, university may grant royalty-free or non-cash sublicenses or cross-licenses, provided licensee pays all royalties due to university from some licensee's net sales. I think that what they're trying to say there is, okay, Mr. Licensee, you can grant a royalty-free sublicense to another business, but you have to pay some royalty on that business's net sales. So it's not really going to be free to us, the university. Now here's the appendix I wanted to talk about. In this case, the licensee has already provided the university a preliminary business plan, and then by a certain date, it will provide a detailed projected product development plan. Here in 2, it'll have another plan saying when licensee plans to proceed product development, its markets and forecasts, and manufacturing and operations and financial forecasts until at least so many $1 million. In other words, it's a very detailed business plan. And again, licensee in part 3 has to have raised so many millions of dollars by a certain date in order to continue development of the technology. And then here are other things that they have to do by certain dates. Have a schedule for recruitment of key manufacturing positions, provide a product in beta test by a certain date, have a first sale by a certain date, have reached net sales of so many millions of dollars by a date. And you can see this is really tight. Now, one thing I wanted to point, I guess I don't have that in here, but there is a provision in the license agreement that says that if the licensee misses any of these dates in Appendix A, the licensor has the right to terminate the agreement or to make the agreement backtrack to becoming non-exclusive instead of exclusive. So there are a lot of teeth in university agreements. So to summarize what we've talked about, several points we've made. Biotech is expensive to bring to market, and university goals do not always line up with licensing goals. We've talked about that. 1980 was a big year for university licensing with the Chakrabarti decision, with the recombinant DNA patent, and with the Bayh-Dole Act being signed into law. It really changed the nature of university licensing, really was a watershed year. We also talked about the fact that universities are streamlining licensing, trying new licensing models with success. We pointed particularly to University of Minnesota and Penn State. And then finally, we talked about while license agreements, university license agreements, are essentially the same as business license agreements, there are license provisions in university licenses that are particularly relevant to universities. And they're much more tightly drafted and tightly drawn than usual business licenses. That ends our presentation.
Thanks, Peter. If anyone has any questions, feel free to put them in the Q&A or chat feature. Again, special thanks to Jim Gould, who did a significant amount of research for this presentation and helped out with gathering the materials. Don't see any questions right now. Peter, do you have any final thoughts for us?
No, I really don't. I just think we're only able to hit the high points in the time we had. But I think the bottom line to bear in mind here is that universities are making great strides in their technology transfer offices to make licenses more friendly toward licensees and more profitable toward the university.
Excellent. Well, thanks so much for your time today, and I will be sending out a copy of the recording and a redacted version of this slide deck later this evening, so you can watch out for an email on that front. Thanks again, and have a great day.
Okay, bye.